Special needs guardianship. A short guide for parents turning 18 is a legal milestone, but for individuals with disabilities, it may not mean complete independence. Parents often must consider whether a guardianship is necessary to protect their child's welfare and decision-making capabilities. Understanding this process can help families make informed, compassionate choices. Legal framework and responsibility. Special needs guardianship is a legal status granted by the court when an adult is found unable to manage their personal or financial affairs. In Texas, this is governed by the probate courts, which oversee the appointment and monitoring of guardians to protect vulnerable adults. A guardianship of the person includes authority over health care, living arrangements, and education. Guardianship of the estate involves managing money and property. Limited guardianships are available for adults who only need help in specific areas. The court may also appoint a temporary guardian in emergency cases or recognize a successor guardian designated in advance. Guardians must comply with legal duties, including annual reports and accountings, under court supervision. If you are considering this option, it is important to consult with an attorney familiar with guardianship law. The law firm can help determine whether guardianship is appropriate and ensure that all procedures are followed properly. Does your child need one? Not every person with a diagnosis needs a guardian. The court looks for legal incapacity, which means being unable to provide for basic needs or manage finances. Disabilities such as paraplegia do not automatically meet that threshold. A thorough medical assessment, including a physician's certificate, must demonstrate the need for assistance. If your child is partially incapacitated, a limited guardianship may be more suitable. Before filing, courts require parents to consider alternatives, such as representative payees or decision-making agreements. Once the guardianship petition is filed, the judge appoints an attorney ad litem to independently evaluate the situation and speak to the individual involved. Ultimately, the judge decides if guardianship is necessary and who should serve. They consider both the child's preferences and the guardian's qualifications. Speaking with a lawyer before this process begins can provide clarity and help avoid unnecessary legal challenges. How the process works. The guardianship process in Texas starts with a formal petition to the court. This must include a description of the person's disability, the relationship between the petitioner and the individual, and reasons for requesting guardianship. The required physician's certificate of medical examination must be completed within 120 days before the hearing. After filing, the court schedules a hearing to determine if guardianship is the least restrictive and most appropriate solution. The court-appointed attorney ad litem investigates and submits a report on whether the individual's needs justify guardianship. If the court approves the petition, it issues a letter of guardianship, granting the legal authority necessary to make decisions on the individual's behalf. The law firm representing the petitioner can assist with each step, from gathering medical documentation to preparing for the court hearing. Accurate preparation is essential for securing a favorable outcome and avoiding delays. Alternatives to consider. Guardianship should not be the default choice. Parents are encouraged to explore less invasive options. Durable power of attorney allows someone to act on the individual's behalf without removing their legal rights, but it must be signed while the individual still has capacity. Other alternatives include setting up a special needs trust, appointing a financial representative, or arranging in-home support services. These tools can be combined to offer comprehensive assistance while preserving autonomy. An attorney can help evaluate which options are most suitable for your child's specific situation. Cost factors and court fees. Pursuing guardianship in Texas involves costs, including court filing fees, medical exams, and legal representation. Filing fees typically range from $250 to $400. Other expenses may arise if it's difficult to contact necessary parties or if extensive documentation is needed. Attorney fees often represent the largest portion of the cost. Simple, uncontested guardianships are less expensive, while complicated or contested matters can become costly. Additional evaluations, including neuropsychological testing, can increase expenses. The court may also require a bond and annual reports, all of which carry ongoing administrative costs. Families should speak with a law firm early in the process to understand potential expenses and prepare financially. Having clear legal guidance helps avoid surprises and ensures full compliance with court requirements. If you believe guardianship may be right for your child, or you want to explore alternative approaches, contact the law office of Whitney L. Thompson, PLLC at 281-214-0173 or visit the office at 4201 Farm to Market 1960 Road W Suite 360, Box number 116B, Houston, Texas, 77068, United States.